And it goes backwards too. We fixed that. It wasn't going back to normal.
Okay, everyone, we're going to get started. Welcome to criminal mediation, otherwise known as what, district court? Criminal misdemeanor.
Yes, misdemeanor.
Mediation. Basically, what we're going to go over today is I'm going to discuss the context of criminal mediation within other research, which is my role. That's what we're going to start out with. Lorig is then going to go and talk much more in depth about the research that she's done to date on the criminal misdemeanor cases. And then Judge Morrissey is going to wrap it all up for us. Okay. And my name is Jennifer Schack. I am the Director of Research at the Resolution Systems Institute. We're a small nonprofit out of Chicago. Our mission is to enhance justice through better use of court ADR systems. And we do that through Resource Clearinghouse, which is online at courtadr.org, where we actually compile and have a clearinghouse of all the studies that we can get our hands on, both published and unpublished, about mediation in the courts and generally. So we have the Maryland studies on our website, as well as studies from around the country and around the world. We also do research, program evaluation, and design programs in Illinois for the courts. And my role today, as I said, is to provide the context for the research that Lorig has done for the criminal misdemeanor cases. And basically what I'm going to tell you is that there isn't much. And the reason there isn't much is, first of all, there are very few studies out there, particularly with this model. Due to a lack of resources, they're really hard to do, particularly these impact studies. And I also think because for this particular model, because it's an old model, and I'm going to go over that in a little bit, but so it's not, it didn't grow up in the era of trying to study impacts and effectiveness. There's also a diversity of programs. Everyone knows about restorative justice and everything that's being done in that area. And so that's where all the studies are being done now. That's a very different model. Again, I'm going to talk about that. And then finally, most of the studies out there, particularly when it comes to criminal misdemeanor mediation, the community mediation setting, and victim offender mediation aren't that good. And most of it is, the comparisons aren't good. There's no backup statistical analysis to tease out causality, and we'll go over that as well. Okay, so this is the universe in which everything else is being done. It's very different. I think I got a little, there we go. Victim offender mediation is one little section of it, and that's probably the closest thing we're going to get to the Maryland model. Everything else is very different and not really very useful for understanding what impacts it might have on the courts, on resources, on the parties in general. Oops. Okay. The studies themselves look primarily at satisfaction and fairness. And fairness, procedural justice issues, a sense of fairness about the mediation agreement, about the mediation itself, sometimes about the judicial system. Reoffense rate, which really doesn't matter in this context, but we'll go into that. Trial rate and hearing rate, which is, and cost effectiveness. Those are the last two that sort of go into what Lorig has done so far with the research. So most of it is looking at something else other than what Lorig has done. So why are there so few good studies out there? First, I want to back up and talk a little bit about impact studies versus effectiveness studies, because people often get these confused. They wonder what the impact is on participants, for example, and they'll say, well, 80% of them are satisfied. That is not an impact study. Impact studies are comparative by nature, and they want to look at whether the intervention itself had an impact on that outcome. Whereas effectiveness studies really are just looking at 80% of the participants are satisfied, 90% think it's fair, 1 in 5 came back to court for some other reason. And that is just saying how effective your program is at doing what it's doing. It's not saying that it is doing better than the traditional process. And that is what an impact study is. They're very hard to do. Maryland is exceptional, and it had a huge influx of funds in order to do these studies. Most courts don't have that, and most programs don't have that. And there's also a problem with availability of data within the court system. Courts haven't really been into the data collection process and making it hard to be able to compare court data, traditional court process data with mediation data. Okay, so we heard a little bit about the gold standard of research. And generally when we think of the gold standard, we think of randomized controlled trials. And this is where you have a random sample, somewhat similar to what happened in the day of trial courts.
It wasn't actually random.
Oh.
No, we randomly picked days to not set days.
So you randomly send people to either the treatment group, which would be the mediation group, or the control group, which would be the traditional group. Those aren't generally done because programs tend to already be in place, and so it's hard to go backwards and say, okay, we're going to deprive somebody of this this service. And courts really like to provide services to people who, excuse me, to people that they think is good, and they don't want to say, no, we're going to just tell these people they can't have this service. So basically, randomized control trials haven't been done within this context. So what the previous researchers have done is they've tried to create comparison groups and those haven't really been done well. And I'm going to show you a few of those types of studies. But basically, when you have a comparison group that isn't done well, you have selection bias. You have a bias towards, there's something else going on with the cases that are going, or the participants who are going into mediation versus the ones that are going through the traditional process. Often in mediation, we think that if we're not controlling well, that the mediation group is going to be a group that wants to figure out their conflict better. They want to get over the issues, and so when you see a selection bias, what you're seeing is perhaps the differences in the people who are going through the different processes rather than the effect of the process itself. And therefore, when we can't really accept that the difference is caused by the intervention, the mediation. A couple of ways in which people have tried to get around that is to match case to case, which is a horribly laborious process. And if you do it manually, not propensity matching, if you do it manually, and often does not get over the biases, you have attrition, or there's a number of issues with attrition and with not having enough variables to match up on, and the variables not being quite right, and so it doesn't quite work. And then there's the whole group of referral rate, which I will discuss in a minute with a different study. Oh, the other thing I want to talk about is the studies also don't really do any post-statistical analysis. They don't do the regret analysis that Lorig likes to talk about with hers, and to figure out how much of what's going on really is being caused by the treatment, and also to make sure that the groups are matched correctly. They basically just have the groups and they look at what happened. So these are the two studies that actually work on the same. I totally missed something? I'm sorry. Okay. I'm going to go back and talk about this. the model that Maryland uses is what I'm going to call the neighborhood justice model, and it's because it really came to prominence with the neighborhood justice centers back in the late 1970s. This model is not the victim offender model. It is much more of a community mediation model, using the same techniques that are used for small claims cases, for landlord-tenant cases, for cases that come in from the community. The same process is used. But the main factors are that it's a program in which the cases are diverted from the normal court process by the prosecuting attorney or the state's attorney's office, handles misdemeanors, mainly misdemeanors in which the offender and the victim have a relationship. Once it is referred to mediation, both the victim and the offender have to agree to go through it. It's completely voluntary. And in Maryland, the process is called inclusive mediation. Elsewhere, it's more of a facilitative model. If people understand what those mean. If not, we can talk about that later. And then the final two are what really set what Maryland is doing apart from the victim offender mediation model that is very prevalent today, and that is that the offender does not have to apologize and does not have to accept responsibility for his or her actions, and that the purpose is to work through the conflict and develop new ways to interact, because these are people who generally have a relationship. So the purpose for a victim offender mediation is to repair the harm to the victim and to the community that has been caused by what the offender has done. So it's a very different concept, and therefore, I believe it's not, you can't generalize what happens in victim offender mediation to what's going on. Back to what I was talking about. Okay. So there are two studies that I could find, and that searched everywhere, that look at this exact model, or pretty much the same model. The first one is the Neighborhood Justice Center study, in fact, done back in 1980. It looked at 3 neighborhood justice centers that were started up as field tests or pilots. These centers did criminal misdemeanor along with civil, small claims, and community. The comparison group was everyone who went to mediation versus everyone who didn't, which, again, we talked about that selection bias. We don't know if, first of all, the cases that were referred to mediation were appropriate for mediation versus the ones that were not, and therefore, whatever is going on in those cases would be different depending on what group you are in. And then, of course, you have the issue of whether they decided to go to mediation or not. The parties that did could very well be different from the parties that did not, and therefore, again, we can't attribute any differences in outcomes to the intervention itself. It could have been something to do with the participants, or it could have been something to do with the case itself.
Sorry, where did you say that study was?
I'm sorry?
Where did that study take place?
It was Atlanta, Los Angeles, Mana something, and Kansas City.
Yeah. I'm an old guy.
But what it did find is kind of this disposition in, for mediated cases, was about just 2 weeks versus 3 to 4 months. For cases that went through the traditional process, satisfaction was very high with the agreement, not as high for the adjudicated sentences, 86% versus 33%, and very high for mediation itself. And then it tried to look at cost effectiveness, but couldn't come up with any good numbers. Because the groups are so skewed, or not really comparable, we're not looking at comparable groups, all I could glean from this really is that it didn't take a whole lot of time for cases to go through mediation. And people who went through mediation were very satisfied with it and with the agreement. Another study tried to deal with this issue of a study in North Carolina in 1992. It looked at, again, 3 different counties that had programs in North Carolina. It tried to deal with this issue of selection bias by looking at the whole group, so from county to county. So there's 3 counties that had mediation programs, 3 counties that didn't. They compared the counties they matched the counties on specific variables, and they looked at all the eligible cases for mediation in each of those counties. So they weren't looking just at the cases that went to mediation, but all the cases that could have gone to mediation if they had been referred. It seems like a very valid research design, but it's not very valid if you don't get a whole lot of referrals, because you can't really have an impact on anything if you don't have a good sample. And so it didn't really find much.
Can I just question, you mean they didn't get a lot of referrals to the research or to the mediation?
To the mediations, yeah. There was a 23% referral rate across all 3 programs, but that included, I could not find the individual referral rates, but 1 program had a high referral rate and 2 had very low referral rates. The one with the high referral rate, actually, they did find an impact on trial rate. It was lower for the mediation county than for the non-mediation county. But other than that, they couldn't find a real difference in time to disposition or trial rate. But they did find that compliance with the mediation agreement was very high and that satisfaction was very high. I don't have percentage, but. So again, what I know from this study is that people are happy and that they tend to follow the agreement that they reach in mediation, and that it's very possible that trial rate is affected, but we're not quite sure. These are, as I said earlier, victim offender mediation programs aren't really comparable, generalizable to what's happening here, but I wanted to talk about another way in which you can get a not very good comparison groups, matching groups. There was a study of 4 Canadian victim offender mediation programs in 1995 where they looked at all the cases that were referred to mediation and then compared the ones that went to mediation to the ones that did not. And again, you have a selection bias because why didn't those other cases not go to mediation? We don't know, and that could be the reason why there is a difference. But I did want to show that there is a lot of satisfaction with the outcome and that people thought the justice system was fair and the agreement was fair. And again, what we know is people like it and think it's fair. And then Catalonia, they did some surveys and found that people like it. So essentially, what I'm telling you is that what we know is that before Lorig has done her research is that people are satisfied with mediation, they think it's fair, and they think they meet the agreement is fair. And that's about it. And now Lori's going to tell you all about her research.
All right, so thank you. Let's see what I've got here. So here's what we did. We're gonna, okay. So what you're getting today is the very beginning, and you're gonna have to come back for more, maybe in like 6 months. So we get you all excited for what we have. And we do have some results to talk about today, but this is really essentially 1/4 of the bigger picture of what we're trying to do with this. So I'm going to tell you what our questions are, what our process setup is, and then I'm going to tell you what results we have so far, which are very promising and very interesting. And it's just the beginning of this particular research project. So first, because I have Luke sitting in the back here, I'll give the shout out because he helped with some of the data collection, and he's working on the pulling together the data set for the next round of analysis as well. So as Jen has said, the challenge in trying to figure out how to do any of this research, and now we've been talking about this sort of since this morning, I'm getting different people in front of me at different times, but the challenge is how do we compare apples to apples? And then how do we make sure that what we think we're giving credit to for the mediation or the approach is actually that, right? How do we account for the other things that might affect the changes? So in the case of the criminal misdemeanor context and any kind of process where there is so much prosecutorial discretion involved, it gets especially tricky. And so what we have is in Washington County, the prosecutor in Washington County uses a criminal misdemeanor diversion process where as cases come into the system, so these might be, a lot of them are second-degree assault charges, usually minor second-degree assaults, but second-degree assaults, destruction of property, often between people who know each other. So the brothers who get in the fight at the Thanksgiving dinner table, or the neighbors who write "bite me" in spray paint on the other neighbor's garage, or one of my favorites. Although I don't know how this actually ended up in court, because the person actually mowed "fuck you" into their lawn, so the other person could see it when they looked out the window. I don't know if it was harassment or what, because they were destroying their own property. They weren't doing it in their lawn. But anyways, people get very creative in their conflicts, is the point. And so a lot of these, and in Maryland, for folks who aren't here, there's two ways that these cases can come into the prosecutor's office. One is that there's actually an arrest. There's police involvement and there's arrest. And some of these, I'd have to look at my data to tell you exactly what percentage of these had arrest or police involvement. But there is enough of a substantial, I'll look at that later and get that for you. But the other way that they can come in is that in Maryland, people can sort of swear out charges on other folks. And I think that this is unique to Maryland, or not every state has this, so I just want to mention this. So I may be in a fight with Janet, and she is calling my phone and telling me that, she's going to get my boyfriend back to her, and that's potentially telephone misuse. And so then I go to a commissioner and I say, she's misusing, harassing me, misusing the telephone. And so now there's charges. And then what happens a lot then is Janet gets those charging documents, and then she goes to the commissioner, and then she says, yeah, Lorig also did this and this and this, and swears out something that involves criminal charges. So there's sort of a mix in this data set, and in a lot of the cases that prosecutors send to mediation, a mix of cases that may have had police involvement and arrests, and cases that may have had individuals swearing out sort of charges on each other. So the prosecutor has the ability to decide on any case, any kind of, there's a discretion about whether they're going to go forward with the charges or not. They can decide that on any case. And then specifically, if they want to offer some kind of diversion, they can offer diversion, right? So in a classic sense, we have diversion to drug treatment, and if you complete this drug treatment program, we won't go forward with the charges. And so mediation sort of fits in that same kind of category, except what's different about mediation is that it involves two people. So unlike with diversion, where you could say to the person, the offender, you can say you go to drug treatment, you finish the drug treatment, we won't go forward with the charges. With mediation, it requires that two people both want to go forward and then go forward with the mediation and resolve the charges. So then, and I'll just talk specifically about Washington County where we did this study. It's similar in other Maryland counties where there is misdemeanor referrals to mediation. But in Washington County, the prosecutor basically is communicating, if you work it out in mediation so that both of you are satisfied, both of you say you're good, then we will drop the charges. So they're not going to send any cases to mediation that they're not willing to drop the charges on. So that's kind of what's communicated to folks. So what we want to know then is, what is the impact of that option to do that, and how is that different than if that option weren't there? And where this gets tricky is that in theory, in another county, a prosecutor can just drop any charges that they want. I mean, they can choose not to go forward with charges if they think they're bogus charges, if they think they're not really appropriate for criminal prosecution. And so we have to be, so when we're picking this, right, this is the theme of the day, is how do you get your control groups. So when we're picking our control group, we have to be extra careful about how we get our control group, but also about the nature of the cases that are going through the process and how we're comparing them then to each other, because whether they end up in front of a judge and going through a judicial process to some extent has a lot to do with a prosecutor's discretion. And so we need to sort of be considering that as we're looking for the similarities between the two groups. So what we did is we picked, so again, as you, I think many of you have been in the conversation, we talked about like the ethics of selecting a control group. And there was a decision not to do a randomized control experiment. a control randomized experiment, because we didn't want to take a place where mediation is currently offered and take that option away from folks. And so we ended up going with Washington County, Frederick County, because Washington County has had this history of this program. They've had it in place for a while. And in Frederick County, the prosecutor's office has chosen not to be part of this partnership. It is one that could be available to them. They've chosen not to be part of it, at the office level. And so here, this question about selection bias, when it's the office choosing to be part of it or not, it's not the participants choosing to be part of mediation or not. And so that's what kind of gives us this sort of pseudo experimental design that we get to have here. So then the next step of the process is to look at what gets a case from the prosecutor's office to the referral to mediation in Washington County. And so we spent a lot of time interviewing both individual assistant state's attorneys, as well as there is somebody in Washington County who screens cases and makes the recommendation. And so interviewing the staff in that office to figure out what is the criteria they're looking at. And then we took that criteria and we created a matrix. And then we went to Frederick County and we looked at charging documents in Frederick County based on that matrix, and we pulled cases out and then contacted those individuals and asked them to be part of the study. Now, again, while we're basking in all of the money that we're rolling around in Maryland for this research study, I'll just say
we want to keep that part down. Discuss things like that.
Well, and so we weren't rolling around in money, but I had to take this actually out of my children's college account. So, but we did, and this is really important. And I think it is important to talk about what it costs to do good research, right? Because we need people to understand that and to be talking about that in other parts of the country. We paid people $10 in the control group to do that initial interview with us, and then we paid them $10 to do the follow-up interview with us 6 months or 3 to 6 months after they finish the court process. And that's really important because with the mediated group, you can sort of make the case of like, would you be part of this research? You're about to get a service, and we want to understand the impact of the service. And we don't pay them $10 for the first interview, although we do pay them $10 for the second interview. But with a control group, you're a random person calling, right? Someone's just filed charges, and then you get this random phone call, and some of the folks who made those phone calls are in this room, right? Good times, right? They're happy to talk to you. They can't wait to have that conversation. And so being able to at least be like, can you talk to me? I'll give you $10. Get them to get through that conversation. So a couple of other things that I'll just highlight about creating kind of the equivalent control groups and then the timing. What we couldn't do with these cases was wait until our control group got to court and then do the interviews in person. So we could do that in the mediated cases, which is much easier if you're not trying to convince a total stranger to have a conversation with you on the phone. So in the mediated cases, we could show up at the mediation table, and that mediation process happened pretty early on, well before the trial date. So people file their charges, they get referred to mediation. Within a week or two of that referral, they're at the mediation table, and then it's maybe a month or two before they would get to court. With our control group, the prosecutor, again, coming back to prosecutorial discretion, actually did close a lot of these cases just on their own, just before they ever got to court, that they would make the determination that this case was sort of bogus and they weren't going to go forward with it. And so we needed to speak with the person before they knew that the case was going to close. So if we waited till they got to court, that would have been a selection bias in that we're only talking to folks who actually the prosecutor has already made the decision to go forward, and so then that biases our data. Like those are the people that we end up in our research. So we wanted to make sure that we're essentially catching people in both cases at the point where they don't yet know what's going to happen with their case. They don't know if they're going to be in front of a judge. They don't know if the prosecutor's going to close it. They don't know if the mediation's going to go well. They don't know if their mediation go poorly and they end up in front of a judge. We're catching everybody at that point. So that's just a technical piece that becomes important in the way that we then analyze the data. It was also really important in why it was harder to collect the data, and frankly why we're only a quarter of the way through the research now, because it took so much longer for us to collect all the data that we needed for this study than if we had just been able to show up and ask people questions in person. Yeah?
Can I just ask a quick question? The one where the mediation was offered, and you said that the prosecutor was willing had already expressed willingness that they could drop the charges.
Yes.
So, but were they retaining the discretion not to drop the charges?
No,
So that the parties didn't actually know whether they would or wouldn't be dropped, or?
So what the parties know is that if they jointly come up with something that is mutually satisfactory to both of them, right? So basically, if they both together say, we want the state to drop the charges, then the prosecutor will honor that. Does that make sense?
Yeah.
So when they go into mediation, some people are going in going, yeah, I'm hoping that we can drop it, especially the defendant. If it's the defendant and it's not cross charges, they're like hoping to drop the charges. Sometimes the complaining witness, the victim, is going in, like, yeah, well, we'll see. I'll sit here and listen, but I'm not, So it's sort of a mix of how people interpret and understand that. But it's not a guarantee that if you go to mediation, they'll drop the charges. And what you see in the data is people go to mediation, they don't resolve it, and they end up with, in some cases, supervised probation when they get to court. And so there's plenty of a mix of other things happening for people who don't resolve their conflicts in mediation.
But some that didn't resolve in mediation might be dropped.
They could still be dropped. Yeah, they could still be dropped. They could be stead. All of the other things could happen, but if they get agreements in mediation that they both are okay with, then it gets dropped. That's right. Yeah.
Thanks.
Sure. Okay, so in the long term, I'll just to tease you and make you come back in 6 months when we have our follow-up party. So our goal is, our overall goal is, we're looking at the impact of mediation on judicial resources, law enforcement resources, individual experiences, and the resolution of the conflict. And so it's very similar if you look at what we were looking at in the district court day of trial study, for example. We have a lot of data about people's attitudes, some of which we're going to use as control variables to make sure that we're really isolating the impact of mediation, and some of which we end up using to track how attitudes change over time for folks who went through mediation compared to folks who didn't. We also are gathering from the police and sheriff's 911, the call centers in both counties, calls for service to the police department before and after, in the 6 months before and the 6 months after, for each of the addresses that was involved in this. I don't have that data yet. That's coming. And then what Luke is working on right now is whether or not people end up back in court in the subsequent 12 months. So while it's not reoffending in the victim offender sense, where you're looking at did the offender reoffend, we are looking at did these two people in their conflict end up back in court because of another criminal charge or because of civil, do they end up with suing each other over something else? Yeah.
So back to my question, you're looking at peace orders as well?
Yes. Yeah, now that's the piece we don't have yet, the 12 months later.
Landlord tenant too?
Yeah, we're looking at any civil, so any civil, so it's good, right? You see these cases.
Oh, yeah.
So they could be, you could like,
It populates all over the place.
Yeah. So we definitely wanted to look at all that. So we have like when you could have a landlord and a tenant that get into a fist fight, right? So they've got criminal charges today, and then that gets worked out, and then they've got a landlord-tenant, suing each other 6 months later. So absolutely, yeah, we're looking at all of the ways they could come.
Because then the juvenile child of the one party is throwing trash into are you looking at the juveniles as well? Because ours sometimes spread out, blossom even into the juveniles.
That's a good question. I don't think we have access. So you can add that to your list, juvenile cases. There you go. Sorry you came.
Was there a specific exclusion criteria?
For the research or for mediation? Well, so for mediation, the state's attorney does have some specific exclusion criteria, and I'm just trying to see if they're in here. They have to do with prior charges that either of the participants may have. It has to do with domestic violence of a certain level, so I don't want to get too far into that debate, but they are, if there's sort of a typical domestic violence sort of relationship, they're not referring those to mediation. And I think and then of course there's certain charges. They don't refer first degree assault, those kinds of things. So they have the charges that they refer, and then they have a couple of things even within that they that they don't refer, but I'm not finding it right this second.
No drug charges.
Was that?
No drug
Well,
charges.
generally not drug charges. Usually drug charges are not, don't end up with people in a relationship with each other. I mean, the drug charges wouldn't be tied to the relationship. In terms of the research, anything that was referred to mediation was potentially part of the research, and anything that was similar to that in our control county was referred to mediation. Okay.
Thank you.
So for the short term, so for the stuff that we are able to look at in the data set that we currently have available to us, the variables that we looked at was what ends up happening and what is the impact of mediation to to whether or not people sort of end up in court using judicial resources or using Department of Public Safety resources or using sheriff's resources in some kind of a way. And so what we wanted to know, recognizing that cases could get closed well before they get to court, that cases could get closed by the prosecutor once they're in court, and that's if a prosecutor closes a case even once people arrive in court, that's a relatively sort of low cost. So in Maryland it would get null prost or sometimes steaded. The steaded is it goes on the inactive docket for a year, it can be reopened, but we sort of counted null prosing and steading as essentially not really taking judicial resources. Now that's with full respect for the clerk who has to, put that in the system and, fill out the paperwork for that. But for the most part, it's not taking significant judicial resources to null pros or stead a case. It does take judicial resources, and this range is if any kind of sort of hearing happens. And so if a hearing happens that leads to guilty or not guilty, then there's, essentially the trial is happening. If even if someone is pleading guilty, then there's the shorter process, certainly, but then the process and then the sentencing that has to happen. There's probation before judgment, and then this is the higher level of judicial resources if a jury trial is prayed. And this is, I need to say that I learn a lot myself. My background is mediation and then the economics, and so I actually am not an expert on all the different things that can happen in the legal system. So I think I've got this right, and then we're working with our advisory group to kind of go, what are all the things that could happen? And so your comment about look at the juvenile as well is a valuable one. But if anyone who knows the district court criminal system better than I do wants to say anything about any of those judicial action items, you're welcome to jump in at any time. So that's sort of our lowest level of here. At this level, we know some kind of judicial resources were used on this case. That's one outcome variable that we look at. Then we looked specifically at jury trial parade. So that means that the case has to go from the district court to the circuit court where there's an attempt to call a jury and a much more costly potential, whether it ends up going to trial there or there's a plea at that point, it still requires the setting of the case in the circuit court and all the costs that are associated with that. Then the next level that we looked at was, did it result in supervised probation? So a lot of these resulted in unsupervised probation. And we're basically saying that while that has some judicial costs, for the most part, unsupervised probation isn't going to give us costs where you have a probation agent who then has to stay on top of somebody and test their urine and do whatever else they do. So was it supervised probation or jail time? We put those together. Not a lot of these ended up with jail time, but a couple of them did. And that's generally pretty short sentences, and those tend to be in the local detention center because they're getting sentenced to, well, certainly less than 18 months. In the local detention center. And then we looked at, did it result in a criminal record for anybody involved? Did the case result in a criminal record? So these are what we wanted to look at. Questions about any of that? So then I talked about see, this is the first time I've done this presentation. Can you tell? So this is what I talked about already. Doesn't it look good? That's what it looks like. So this is just how we created the treatment group and the control group. I did. And then how we did the data collection. Well, there you go. And so our long-term analysis, we'll include the other stuff that I've talked about, the court records, and then the police calls for service. Okay, so this is the fun part, right? This is where we got you to talk about propensity score matching. So this is, right? You're waiting for this part. So this is the apples to apples piece. So we did sort of essentially 3 levels of safeguards to make sure we're comparing apples to apples. So the first thing that we did was we did a difference of means and chi-square test where we looked at our groups and we said, what are the statistics? So remember that we have a bunch of survey data. We have a bunch of court charging documents data, and so we're able to create a pretty substantial data set with characteristics about these cases, as well as information about the attitudinal variables that people have answered about how much they hate or love the other person involved in this case. And so with that, we start with the difference of means test. And so this tells us, just if we take kind of point by point, is there a statistically significant difference between these groups on whether or not they were lovers or ex-lovers, right? Or whether or not they're immediate family members, or whether or not they're neighbors, or whether they're strangers. So all the different things about the kinds of relationships we might have, we can say, no, between the two groups, they're essentially the same sort of kinds of relationships. Is there a difference in terms of whether there was police involvement before they got to this point? And we can say, no, essentially they are the same in terms of police involvement. The places that we had statistically significant difference of means between the two groups after we tested it for about 25 different areas was the 4 places that we had were that the mediated cases, there were more likely to be cross charges. The mediated cases that were more likely to have had somebody had consulted an attorney. Mediated cases were more likely to have more second-degree assault charges involved, because you could have multiple charges, and more likely to have had a prior conversation before they got to the mediation table. And so what that tells us is that for the most part, these two groups are similar, but now that we know that these are areas where there's a difference, now we're going to control for these things so we can make sure that it's not these things that are affecting our outcomes, but that it's other, that we're still have those controlled for, because those are differences in the groups. Please.
You're more likely to have had prior conversations?
So before you got to this moment, have you guys talked about this? So in the mediated
Talked
group,
about the conflict.
That's
not
right.
Did you ever talk to each other?
That's right, yes. Have you talked about this conflict before this point? And so the reason we wanted to know that, we expected it would be higher in the mediated group, because if the people are going to mediation, they've had time between when they filed the charges and when they're getting to the table, and they may have had a conversation in that time period, whereas the people who were catching right after the charges were filed because of that timing issue that I was describing wouldn't have necessarily spoken between when the charges were filed and that point.
Well, while I've interrupted you, can I ask one other question, which is, how big is the whole sample group in Washington County?
200 and, well, the full, there's 206 cases total, and about 40 of those were mediated and 60 were not, which is good, and I'll tell you why it's good that that there's more in the control group. I'll tell you what.
206 in Washington County.
190 in Washington County. Guess I have to look at this. 206 is the total data set. Yeah. Okay, so that first thing we do is is the difference of means test. The next thing we do is propensity score matching, and I promise I'm not going to go too far into this, but what propensity score matching does is it allows for, it's a relatively new, actually, here's how old I am. I didn't learn this in grad school. So it's a relatively new statistical technique. It's used a lot in criminal justice research, and it allows for much more rigorous analysis on real-world data sets. So when you can't do controlled randomized experiments, it lets you take the real-world data sets and it gives you sort of this second best matching, where it essentially looks at the characteristics in your treatment group, in your mediation group, and it looks at your control group, and it finds matches that it essentially says, for the stuff we're looking at, these two cases look pretty similar, let's keep them in the data set. And these two cases look pretty similar, let's keep them in the data set. And these look similar. And this is where I was saying a minute ago, there's a benefit to having a larger control group than your treatment group, because what it'll do is it'll then just get rid of the control cases that don't have a match in the treatment group. And so that lets it be sort of that much closer to actually having compared to kind of equivalent sets of folks. So we do the propensity score matching. And then we can say, and then from that, we get the data set to drop all the control cases that don't have a match with the treatment cases. And now we've got sort of an even tighter data set, and then we do logistical regression analysis. And the logistical regression analysis, we've been talking about regression analysis, I know you all know, so I won't bore you with the details, but it lets us isolate the impact of, in this case, the mediation on the outcomes that we're looking at. And so after we do the regression analysis, the logistical regression analysis, then we can get predicted probabilities. And the predicted probabilities are the impact of mediation, how it impacts the likelihood of these things happening, even controlling for all of these other differences that might be there in the groups or these other things that may be going on for folks. And so our predicted probabilities, where we found mediation to be statistically significant, it decreases the predicted probability of any of the judicial action by 24%, jury trial parade by 11%, and supervised probation or jail by 7%. So those are our outcomes, and that's yours. That's yours. Yeah. See, I know what's coming next. So those are outcomes, and then what we'll do next is we'll be able to look at what the impact is in the 12-month context, and then also on the police calls, and on the participants' attitudes towards each other, the shift in their relationship and what they say about it. Questions? Yeah.
So, one thing that you said at the outset is obviously there's different models in the state. And this is only one model, which is the state's attorney controlled version. Is there a plan of trying to compare the other models, like the community mediation or community conferencing, or models that do not have state's attorney referral?
So when we, so the cases that are in this data set, just to clarify, are in Washington County, are referred from the state's attorney's office, but they're referred to the community mediation program. So that it is a community mediation approach that's being used, that's being studied here. It's just in the context of the state's attorney referral to them. We're not looking at all the cases they're mediating, just the state's attorney cases. And then to the broader question, I think when we, and for those of you who were here in 2010, November 1st, who was that? Anyone in this room was here? And we went into that room saying, here's all the stuff we'd like to study. Can you help us narrow it down? And all these experts who came from around the country didn't help us narrow it down, they helped us add to it. And so then we had twice as much. So the judiciary's priority was to measure the impact on the judiciary of essentially directly judicial related programming, recognizing there's a value to conferencing and mediation that takes place before cases get into the system. But all the cases we studied in this particular research set are cases that were in some ways involved in the judicial system.
So the short answer is not at the moment. There's not a plan of, we'll take these numbers and then we'll do another one with a Baltimore City model in Anne Arundel County, there's an in-house mediator who works for the state's attorney's office.
Yeah.
We're not comparing that.
So I think you could legitimately say that these numbers are probably applicable to other community mediation referrals, right? So in the places like Baltimore City where the referrals are made to the Community Mediation Center, I think you could say there's reason to believe you'd get similar kinds of results. But yeah, and then you could argue one way or the other about whether they're applicable if there's an in-house mediation program like Montgomery County or Anne Arundel County. If you get similar results, I'm sure some people would say, yeah, it's probably pretty close, and other people might say, no, it's actually a different model, so you can't. But yeah, this one didn't look at the what works piece of it. This is just the impact part of it. Yeah.
I realize that there's still a limited amount of outcome data available or analysis available, and I'm curious if you have been surprised by anything or excited by or anything so far.
Well, I'm excited by the propensity score matching. To be honest. I'm not surprised, you know, I will tell you, I think I was surprised with the supervised probation and jail time. I did think that, I think I didn't think that it would necessarily have that impact because it's such a small number of cases that sort of end up in that realm, in both Frederick and in Washington County. And so of these kinds of cases, I think I was surprised by that figure, but not really. And I think once I look at the rest of the data, there may be other surprises that we're not expecting. It's very close. All right, I'm gonna give it to you now that I messed up all your papers.
Okay. She didn't even bring a copy of her own draft with her.
I didn't.
And it's 18 pages long, I believe.
Yeah, I messed them all up. It's
That's
18
okay.
pages, yeah.
It's 18 pages long, and my staff gets me ready for these kind of things. So last night at home, I was reading this, going over it, and I was actually excited when it got to the graphs, like there'd be whole pages of graphs, because it's really hard to read. You have to be into it, but it is understandable. But I get to the graph, I'm like, woo, there's a page going by. Then I get here, and it's summarized into one page, and I was like, but so when I look at these results, I'm always trying to figure out, what am I supposed to do with these results, right? What does this mean to us? How can I use the findings of this to tweak the system or to improve the system, or what does it show me? One of the first things, my mind just always was businessman before I became an attorney. My mind goes to costs and savings and things like that. And even if you look at it, like if it was 200 people in this set, and we're at about a 25% predicted probability less of judicial action, so that's 8 people out of those 200 that didn't make it to a judge, right? And when you think, even if they're going to go for a judge, it's going to take, if it's going to be a dispositive outcome.
It's 50 people.
Pardon me?
50 people?
Well,
Sorry, I'll let you go.
that's a lot of savings, and it's even more than I thought. So let me just make sure I understand. So out of those 200 people, they all mediated?
Well,
So
yeah.
that's where I got the 8 from.
Yeah, and you don't want to, it's not that 25% of this data set, it's that if you took 200 people, and that 50 of them would have ended up in front of the judge and don't end up in front of the judge because of the mediation.
Okay, so we can use 50. It's not as easily roundable as the 24 I was working toward, but what it means to me, even if you put an hour on each one of those cases, which probably is light, I would think, saying an hour, because even a plea can take a considerable period of time when you're doing a plea in court. But if it goes to a trial, you really can, even a one-person trial is going to take you at least an hour, probably closer to 2 hours, and usually there's multiple witnesses. So you figure that 100 hours of court time, right? Now you're talking about dockets to me. You're talking about whole days of dockets. And what that means is that I can do either a couple things. I can fill in those dockets with other criminal cases and then move the whole system quicker through it, because justice delayed is justice denied. We're very sensitive about those things. Or I can use different mix of cases. One of the things that most people don't realize is that our mix of cases changes depending on what the legislature does and what they enact. And so 4 years ago, there was no such thing as a red light camera docket, right? Now there is, and there's considerable of them. 2 years ago, there was no such thing as a Maryland toll violation docket. Do you know they have their own police, by the way?
Yeah.
The Maryland Toll Police, and they love to write tickets. Of course, it's all electronic, so they don't actually, I don't know what they're doing out there, you know what I mean? It's all by sensors. So, you know, there's whole new dockets that sometimes come up. We have to find space for this. In the legislature, historically, when they enact these things, they ask for official fiscal impact statement, and then they completely ignore the fiscal impact statement. And they don't give me new judgeships, and they don't give me new pins. So something like that, a program like this that occurs really outside of the courtroom, before it even gets to the court, and that's the earlier it comes on, the more savings it is to us in the court, is extremely beneficial to us. The other part that's very interesting to me, and it goes to your point about what's the screen out, and the screen out sometimes is very difficult, like in our drug, when we have drug treatment courts, sometimes we have to screen people out in Prince George's County because they're residents of the District of Columbia, because when we go to offer services, we can't offer services in the District of Columbia because they don't cooperate with us. It's a different jurisdiction. We've gotten over a lot of those issues and had to work through all those issues. But Maryland's somewhat unique in the sense that individuals can come in and just file charges. And what I would love to see is the state's attorney doing screening, whether it's a mediated screening or a screening, right initially when these individuals file at the commissioner's office. Because the commissioners have to accept what they're saying, basically is what they're putting down. And you'll see these stories all the time. There was just an article that they keep publishing about a woman that was in jail for 5 days because her sister, who has psychiatric issues, had made up a completely fictitious complaint against her. And they're somewhat critical of us because we're supposed to have the wherewithal to know that the sister was psychotic, first of all, which there would be no way that we would know that, and that, it was a first-degree assault with, alleged serious bodily harm, that we have to act like it is the way it is. So if you can get to a screen with those cases and kind of try to cut through what it really is as the dispute that they're having, a lot of times they default to criminal because it's quicker and it's faster and it's less expensive than actually doing a civil trial. Most of the times it really delves down to more of a civil issue than a criminal matter, at least in a significant part of it. I think that would be a huge benefit too. And at that stage, then put them in maybe, and I can understand people, I get a lot of letters that say, the state's attorney didn't prosecute this case, they dropped it, I feel like I didn't have justice served. This may be an alternative for something like that, where, okay, maybe your case doesn't have the greatest merit in the whole world, but maybe everybody would be served by this a little bit better if you went through mediation and try to resolve this, so 3 months later you're not calling the police again and going through the same issue. I had a trial at one point. The gentleman had, he would take his trash can, so if one house's driveway was here, the other house's driveway was here, he would take the trash can and move it all the way to his neighbor's driveway, but it was still on his property line. He clearly marked where his property line was. So really he wasn't doing anything wrong but being a jerk, right? I mean, he was real, but he was really torquing the other neighbor, and the other neighbor's there, he's charged with malicious destruction of property. I'm like, really, where is this, is this how I've decided to spend my life? My career goals is presiding over a case between a dispute about where people are putting their trash cans. Has it really gotten to this level? Well, then the state's attorney shows me the complaining victim's video, and the guy comes out of his house and he takes a baseball bat to this trash can and rips it up into pieces, and then takes the trash and throws it all over the neighbor's yard. And, at that moment I went, well, that just escalated a little bit for me right there, because there's a violent issue to it. So he's only charged with malicious destruction of property, right? And destruction of a trash can, theft less or whatever, destruction less than $100 is not very major, right? But what if that guy came out of his house while this was going on and the other guy had the baseball bat? You can see where that would go, right? And if we can get mediation in there before something like that happens, I think that would ultimately benefit everybody. It benefits society generally. So that's really all I have to say. I'm excited. I just found out about these results too, and it's very interesting. And now the challenge is for all of us is help me figure out what we do with all this information and how we manipulate it to make it work in our system. And it's kind of what we've been successful doing in the civil side. Maybe it can apply to a greater degree in the criminal side of it. So thank you.
I want to follow up on something that Judge Morrissey just said about the story about the neighbors with the garbage cans. It kind of puts this more into a national context. As I mentioned earlier, there's been a real push towards restorative justice, that taking these misdemeanor cases and turning them into a question of responsibility by the offender and repairing harm to the victim. And coincidentally, just yesterday, an article came into my inbox that really argued that we had to go away from that again, and we had to come back to this neighborhood justice model of mediating misdemeanor cases in a way that deals with the relationship and the conflict. And in the main, because most of these cases do involve a relationship, but also because who's to blame isn't really clear. I mean, obviously, one of the neighbors in this story about the garbage cans was a jerk and moving his garbage can right over to the property line, and then it escalated into something where the other neighbor then was arrested. But both of them are to blame within the situation.
Or neither are true.
Or neither.
Depending on perspective.
True. So this article is very good theoretically, but what is really good with what Maryland is doing is now we have the data to say, yes, and this actually works. And I'm really looking forward to the long-term data that looks at, was the conflict resolved, and were the police called more often later, and what were the differences in attitudes, because that's getting at the purpose, and it's also getting at the reason why this article, and I would argue that we need to maintain this sort of mediational approach to these cases.
What I want to know from Dr. Lorig's case with the person that mowed the cuss word is, how did the other neighbor know it was directed to them?
That's a good point.
Could it just been a general
It's just a
society?
joke to the world.
Yes.
Mowing the arrow pointing Did you, in your intro about the selection criteria, said that it included second-degree assaults and harassment, et cetera, but did you find in the interview process of prosecutors that it was consistent from prosecutor to prosecutor? Or, were there very clear guidelines from the office, or was there enough prosecutorial discretion that you were kind of averaging out what different prosecutors could do?
Yeah, I think that for the broad, I suspect that individual prosecutors probably do things slightly different, but for the broad level of what we could garner then from a charging document in Frederick, there was essentially consistency at that level, like what the charges were, what the relationship might be, whether or not there were priors. We had to look at people's, whether we had to look in case search for prior charges and convictions. So those kinds of things that there was agreement about were essentially what we could gather from Frederick anyways. And so I think there probably are differences, judgment calls about individual cases, but overall there was enough consistency that that's how we could create a control group.
Did you try and, I'm assuming that when they selected a case for mediation, it still has to be voluntary.
Mm-hmm.
So some people could say no.
Mm-hmm.
Did you try and figure out who would say no statistically, and what was more likely to make them say yes than no?
Yes, not exactly, but we did, there's another level that I didn't talk about just because that was, just because of time, where I did also have attitudinal data, and we used that in our regression analysis to the extent that there may be that added selection bias at that point where kind of more cooperative people ended up going. And so that was sort of where we controlled for that. But this analysis is not about what makes people go to mediation or not, although that's a really valuable and important one too. Yeah.
It would seem like, I think there is a study that you did on this day of trial, mediation in the district court, where it makes a difference what the judge said.
Yeah, I didn't do that one,
If the
but
judge says this, then people are
where
more
is that
likely
one?
to go, someone did that.
That's a different bit of research that hasn't been published yet,
Okay.
yeah,
done by
I-
different
But
researchers.
someone has found it matters what the judge says.
Oh, yeah.
If the judge says it
Sure.
this way, folks are more likely to go. If the judge doesn't say it that way, they're less likely to go. So maybe that might be valuable in this context.
absolutely, absolutely. Yeah, Rachel?
It's been my experience in mediating criminal misdemeanor cases for community mediation in Baltimore City that when there is an agreement, that it often has a really much wider impact on spouses, children, neighbors, that this isn't an isolated kind of thing often.
Yeah.
And so it would be great if, when the judiciary, because of the national importance and because this is the hottest thing happening in the ADR field, when the judiciary funds more research, it would be great to find some way to capture that community impact.
Yeah, so a little bit of that will be captured when we do the attitudinal relational questionnaires. Like that's the set of questionnaires that we haven't, that's not done yet. So that's one of the sort of, out of the 4 that we're going to look at, that's one of them. This is 1/4 of it, as I've been saying. So some of that will be captured there. Now, what that won't include will be like the kids who no longer watch their mothers fight with the mother, with the other mother, that the father, has kids from 2 women, and the kids not seeing that anymore. Like, we won't capture that stuff, but we will be able to capture the transformations in the relationship between folks. That piece will be there. Lisa.
So this is a question for the whole panel. I am picking up from the comment I made about the 10 top data fields for dispute resolution that courts should collect that the ADA has on its website. There's a move nationwide toward big data systems. And when you are talking about a number of the pieces of information, for example, that you needed to do propensity scoring.
Yeah.
I mean, you're manually collecting a ton, for lack of the descriptor that is a four-letter word, I can't even, stuff that could all be automated. It could be collected in the intake of a case and just be there in the system. And when I think about what Jen and RSI do, I mean, Resolution Systems Institute, is that still what it's called?
It is.
You know, that's a central repository now for evaluations, a lot in Illinois, but also other evaluations of state courts that we don't have, because I had a conversation with Paula, who's on a panel in another room. And the National Center for State Courts for 20 years hasn't done this research. The Federal Judicial Center, Donna Steenstra, was spending 2 years calculating the size of courtrooms instead of doing this research. And how much better would life be for all of us in terms of both the people paying money to the researchers that they don't have in their budget because the legislatures aren't appropriating enough money in the judiciary to begin with. So where this money came from to pay researchers is of course a question. I don't want to know, it's a good thing. But why can't we do this? Why can't we do better data collection in the courts?
Well, how do we capture people's perception? I mean, how is that? You have to remember, when people come to court in a criminal, when people come to court in a criminal situation, it's not really an opportunity for the court to investigate or to interrogate or to ask questions. We're the neutral, impartial body there. The data capture really has to be by somebody else that's not the judiciary, or the people have agreed to do it. But that's not really the role or the function of it. Can our data, and can we build a system that captures more data? Absolutely, and we're trying to do that. It's wildly expensive. I do, however, caution that the use of big data is very dangerous in a lot of instances. We just got through a study with the Pew Foundation, and they look at, let's just take an example, they'll look at all people that are in on charges that are under 90 days and try to determine how long they've been detained pre-trial. Well, a person can be in on a misdemeanor, right? That could be, the distinction between misdemeanor and felony has collapsed over the years. They're really, it's not that distinction that it used to be 30 years ago, because there are some very, very serious, an attempted first-degree murder is a misdemeanor, okay? Attempted arson is a misdemeanor. So you can have some very serious charges in there, and the caution is that when you group all of these cases, when you group theft less than 500, you say 50 people are there and they've spent more than 10 days in jail on there. What you have to do is dig down even further. You have to go to the case level and you have to look, okay, why did this person get a $500 bond on there? And what it'll turn out in the majority of times is because that's that person's 18th time. Now, you can have a whole discussion whether money bond is correct in that instance, or whether an 18th time deserves a $500 bond. But to group that person in with a person that's also charged with the same thing that has no prior criminal record, I'm more interested to see that, quite frankly, to make sure we're not putting a bond on that guy, because that should be a release on recognizance. So I just caution on the use of big data. Every case is unique in a lot of instances. A second-degree assault can be someone taking a baseball bat and hitting another person with it because it got stepped down from a first-degree assault because the officer didn't show up at the probable cause hearing, which happens all the time in district court, to someone spitting in the direction of a police officer. Are those two the same? I don't think they are, and I just caution the use of big data for that reason.
can I just say, I think a piece of what you're saying though, Lisa, is to get a little more of the nuanced data into the systems. And I think that's exactly the same point you're making, is that if we had slightly more nuanced data, even if it's not this level of survey data, that would allow for us to correct for the problematic uses of the big data that doesn't capture the nuances.
It would be. It's just, it's exceedingly
expensive.
difficult
We know.
and expensive to do. I mean, I'd love to. I have to deal with PIA requests all day long, and I'd love to be able to just give the data. I have no reason not to give the data. The data is whatever the data is. It's just that, you know, everybody has their own little, you know, some people say, I want your entire database from 1972, and I'm like, good, give me $1 million and I'll produce it for you, you know? I don't have, you'd have to get a room this size of a computer to put that data on. But I agree, I'd like to capture more data. There's some limit that we're probably able to do. We're looking at all those issues in the judiciary.
I think we're supposed to be done by 2:45. I
Sorry.
don't mind saying, no, that's okay. I think but I don't mind staying and answering more questions. But folks feel like they need to leave, make sure you fill out this, and we'll just keep answering questions, and you can sneak out when you want. Sharon, were you going to ask a question?
I wanted to just make a comment, and I was going to write it down, is that part of what this use of big data, I know in Florida the big issue was the judiciary never wanted to collect the data because they didn't trust the legislature to use it appropriately. And I think so my suggestion was going to be, in addition to all the people that need to be educated, it's the legislature, so that they understand what it is that they're seeing, and that they don't say, oh great, we don't have to fund any more judges, which is not the answer. And so that misuse of the big data leads to people being afraid to collect the data because it's not going to be used correctly.
There's a whole nother issue that's somewhat related to that. That's really the crossroads of the historical transparency of the court, and now moving into the electronic world with what's available remotely through things like case search. And case search, as Dr. Lorig mentioned, was used in a very valid experiment and was very helpful to her in doing that. But there's also a whole industry of people at 3 o'clock in the morning, you know, screenshotting your cases and putting them on databases and selling that from the website, or looking up their neighbors to see what they did in 1986 in Harrisonburg, Virginia, which it wasn't me. So, you know, how much do we show, and how much do we, you know, my natural tendency is, it was kind of beaten into every judge, I think, I don't know where from, but it's to be as transparent as possible at all times. Nothing's ever secret, everything's open, nothing's subject to confidentiality unless by rule or statute. But now it seems like people are really getting hurt by the fact that someone can go online and they can be denied employment for something that happened 15 years ago because they haven't taken the time to expunge the case. The Rules Committee has been tasked, Judge Wilner, former Court of Appeals judge, has been tasked with bringing together a committee, which he graciously asked me to be part of, to look at that issue. And I'm somewhat in the middle ground on it. What I need is them to come up with whatever the plan is going to be, taking in, we have all the stakeholders represented, so that I can build the data system around it, because that's one of my main jobs, is to do these kind of things. And it's important to me because moving forward, it's going to form part of the foundation of everything else we're doing. And as part of that, I can incorporate in other data elements that we're going to try to capture on all this, but I can't do that. You know, right now, the case search is built on technology from 1995. No one understood how the technology would take off in today's day. And so I can't I either have to turn it all on or turn it all off. I can't take, you know, certain parts of it out and not show other parts. And it makes life very, very difficult, because when the legislature enacts certain things, they want me to be able to do that, and I just can't right now. I've got to fix that problem. It's a major issue right now. So. We're kind of getting off track, I think.
One of the ways these mediations differ from others is the involvement of the mediator in the drafting of the agreement.
Right.
Did you look at that variable and how it differed?
Well, no, because, so on these cases, this was just an impact study. I was comparing case that went to mediation, case that didn't. This wasn't drilling down into the process. So no, we didn't look at that piece of it. Yeah.
Our system's set up where we're capturing data for those that have entered into the court system at some juncture, whether through the commissioner's office or filing of a complaint, we have a lot of pro bono programs out there that are collecting data on their clients. And I'm wondering, have we looked beyond the courthouse steps and looked at what those organizations are doing, because they're doing mediation as well. They're doing the pre-litigation, pre-entering our system. And I think that has a dramatic impact on our courts, because it goes back to my earlier point of the unmet needs. Those are parties that are using mediation or could use mediation in a way that's effective, and perhaps the successes of our mediation can be applied to them.
Yeah, so like in the context of community mediation, which is one I'm very familiar with, right, across the state, there's 18 centers that are doing all kinds of mediation before folks ever get involved in the court system. And I think you could make the case that they're keeping cases from ever getting into the court system, and that's the case that a basis on which Macro funds their work with judiciary money, because they take a lot of cases out of the court system, but they also do a lot of cases before they get to the court system. The tricky thing from a research perspective, so to some extent, what Judge Groom was saying a minute ago, like, did we study that? We didn't, because this study was really focused on once people are in the system. The hard thing with prevention, right, which is so important, but it's always hard to measure the impact of prevention, because how do you know what didn't happen, right? And so from a research question, that's the trickier thing about measuring. So we have data from those programs about success rates and satisfaction. We have data about people 3 months later saying that their agreement's still working for them, but we don't necessarily know, we don't have something to compare it to know what we kept from happening. And so that's on a rigorous research perspective, that's what makes that piece trickier to do. But I absolutely agree with you in principle that they are keeping cases from getting into the system, no doubt. All right, well, thanks. We'll see you soon. Sorry for stealing your material. I thought I actually thought.
Do you want it?
No, I have it. I thought the whole thing was going to go in here. That's why I thought I was going to reference it. You were excited.